Welcome back people to yet another brilliant tutorial in my Kick-Ass McKenzie Friends series, helping you through family court. Today, and this is big news folks, I'm going to explain the new provision of family court publicly funded advocates available for litigants in person where there is domestic abuse and parties have to cross-examine each other. Now, this provision covers all aspects of family court cases where cross-examinations are needed. For example, in charge arrangements, this could be at fact-finding hearings and final hearings. This new provision could be a game changer. I am Philip Kedge, the Kick-Ass McKenzie Friend, a retired police chief inspector, the director of the McKenzie Friends UK network, the founder of the national campaign of #LikeNotHate and fearless family court vlogger. Nothing I say constitutes legal advice because you don't need legal advice and you don't need lawyers. I provide guidance and support as a layperson in layperson terms. Don't forget to like, share, subscribe and hit that notification bell. Let's do it. We know that the Domestic Abuse Act of 2021 came into force on the 29th of April 2021, which prohibits a litigant in person from directly cross-examining the other party when specific criteria is met. But in layperson terms, this centres around where there is proven domestic abuse or allegations of domestic abuse against the other party. In other words, an alleged perpetrator of domestic abuse cannot cross-examine an alleged victim. In the same breath, the alleged victim should not be expected to cross-examine their alleged abuser. Now, many alleged victims of domestic abuse may have legal representation through legal aid or may be self-funding lawyers. On the other side, an alleged perpetrator may be self-funding a lawyer, so this provision won't assist them. It is only for litigants in person who are not legally represented. The notion that an alleged victim of domestic abuse can get legal aid and the perpetrator alleged not being allowed to put questions to them directly has obviously raised the issues of fairness and the right to a fair trial under Article 8 of the Human Rights Act. Over the last year, the courts have put a sticking plaster on the problem by inviting alleged perpetrators to hand their questions to the judge to ask them on their behalf. Not very satisfactory. But folks, for cases that fall after the enactment of the Domestic Abuse Act of 2021, that has now changed with the provision for a litigant in person being able to apply to the family court for a publicly funded legal advocate. So what does an advocate do? Well, an advocate is going to be a barrister or solicitor who are registered on the court list to be legal advocates and have been trained in the role. Their job is to take the court bundle and to determine the questions that need to be put to the other side in relation to the issues and disputes and to cross-examine the other party. Now, this is very important to understand. If a court appoints a publicly funded advocate for cross-examinations, that advocate is not legally representing the party. They are acting on behalf of the court and assisting the court. They are not the lawyer for the litigant in person. They are not representing the litigant in person, and they are not following the instructions of the litigant in person or advising them as to their case. So their role is restricted to ensuring that questions are put to the other side during contested hearings. Still, nonetheless, this is good news for all litigants in person where there is domestic abuse and the criteria is met. Now, this of course means that you still need a McKenzie Friend from the McKenzie Friends UK network to support you through court, to help you with all aspects of your case and to attend court with you. You remain a litigant in person and are still entitled to a McKenzie Friend. Remember, you don't ever need to pay tens of thousands of pounds on family lawyers, leaving you in crippling lifelong debt. So, where can you find out more information about this provision? Well, contact me of course at contactphil.co.uk and fill out the form saying something like, "Phil, thanks for another brilliant kick-ass vlog. Please send me information on the family court appointed advocates." When you contact me, I will personally send you a link where you can download the relevant legislation. You can download the Family Court Practice Directions that explains the criteria and the procedures. And you can download the application forms you need to apply to the Family Court for a publicly funded advocate. I will also explain how to submit it. So that's me done. Please contact me for all your family court needs. If you want to find a McKenzie friend, if you want to watch all of my Cafcass and other family court vlogs, if you want a one-to-one case review with myself, or perhaps you want to become a McKenzie friend, contact me right now at contactphil.co.uk. Until next time.